You observed the taking of property and have detained the suspect. What should you do next? We'll tell you next on ProForce. Hello, I'm Mark Brendan, and welcome to this edition of ProForce. In the next half hour, we'll continue our discussion on search and seizure. The focus this month will be the Fourth Amendment of the Constitution and how it applies to you. Our instructor for this program is Rick Feames, Director of Public Safety at Black Hawk College. Let's join him now.
With regards to searching, probably one of the most important things for you to understand when it comes to this is to understand thoroughly the standard you're ultimately going to be held to. When you conduct a search and you get involved in any way in any kind of a seizure, the standard that you're going to be held to is a simple one. It's called the Fourth Amendment to the Constitution of the United States. And I want you to understand and listen carefully to the words that make this up. The Fourth Amendment goes like this: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or the things to be seized. The key word here with regards to the Fourth Amendment is unreasonable searches and seizures. Another key word to remember is probable cause. Let's talk about those for a minute. If you look carefully at what the amendment says, it doesn't prohibit every search. It just prohibits unreasonable ones. And you have to appreciate as a security practitioner that reasonable searches happen all the time. We are in the business of conducting reasonable searches. A search of significance occurs when a person is seized. The seizure of a person we call an arrest, and once in a while we do get involved in the business of arresting. And when that happens, without doubt, without any question, when an arrest happens, public or private, the Fourth Amendment protections are going to be invoked. Now, I already gave you the definition of probable cause, but let me hit that a little further before we go on. Probable cause is those facts or circumstances that would cause, and listen to these words, an ordinary, reasonable, and prudent person, that's you, to believe that a crime either had been or was being committed. Keep those definitions in mind. Reasonable searches are okay. Probable cause is an element. When it comes to what we do as practitioners, the courts are going to go right back to that same standards. They're going to look at the totality of the circumstances, and they are going to use that totality of the circumstances to determine whether or not that was reasonable under those circumstances. What's that mean? It means this: justification to stop someone does not necessarily mean that a constitutional situation has developed.
Hey, sir, can I find anything?
I was wondering where Star Bank was.
Well, if you go right around the corner here to the main entrance, it's right there on the left.
Okay.
Okay? 201 dispatch. Dispatch, I got possible male with a gun on the level 1 retail. It'd be a white male in a dark suit. Could you request police for me?
Anytime we stop anybody in the security business, any stop that we make to talk to someone must be based upon a reasonable suspicion. A reasonable suspicion, to get back to that definition, is one that we can articulate. We can explain to a trier of fact why we did what we did. It is not based on hunch. It is not based on feeling. It is not based upon prejudice. It is not based upon innuendo. It is based upon clear and articulable reasons for why we did what we did. And those reasons have to be backed up by either law or guidelines or work rules or job description or something else. You've got to have something to fall back on. Now, it's entirely possible that this reasonable suspicion that we're working on could turn into probable cause. And if in fact it does happen that this reasonable suspicion develops into probable cause may well result in somebody being detained. Okay? In other words, a seizure. That could happen. The key here is making sure that we understand that one thing flows from another. The reasonability concept is everything. When we're talking about seizure of people or we're talking about seizure of things, that is something that requires absolutely and without any question articulable facts and circumstances. And I can't stress that enough. You have to be able to put down those circumstances, those facts and those conditions in that particular situation that would cause you as a reasonable and cautious person. That's an important concept. You're not acting recklessly. You're being deliberate and you're being cautious about what you do. That would cause you to believe that a crime was committed and that the persons or things that you are attempting to seize at that time are an integral part of that crime. If you can do that, you're on pretty solid ground. If you can't do that, stay out of the search and certainly stay out of the seizure. You're going to get yourself in trouble. I wish we had what law enforcement has by way of guidelines on one hand. On the other hand, I'm kind of glad we don't, because the guidelines that they have, please remember, are guidelines that were given to them by other outside entities. It's not something that they developed professionally. They got them shoved down their throat. Hopefully what we're doing is going to be based upon solid professional functions. Okay, what's not a seizure?
To base. I need you to stop a maroon 240 SX and go ahead and notify PD at this time. I sure did. This car has some stolen property in the trunk. I went ahead and stopped them and waited for you to get here.
Okay.
What you just witnessed there with what that officer did and explaining to that police officer what was going on, the way that he explained it, is one of the biggest mistakes that people in our business made. What he did was tell a police officer what he thought he saw. And that's the kind of thing that gets us leading down that slippery slope to a lawsuit or to a claim of false arrest, false imprisonment, unlawful search, and unlawful seizure. Those are the kinds of things that happen all too often in this business. And it's the kind of thing that with training and with a little understanding, hopefully is not going to happen to us. That officer now is faced with a situation that's going to place them at risk as well, based upon what that security officer said. That's not the proper way to do it. This is.
Hey, how you doing?
Pretty good. I was on patrol and I noticed a car sitting in the parking lot, and then I saw the subject come out of the building. Mm-hmm. He had some items in his hand. He placed them in the trunk of the car. He went, shut the trunk, jumped in the car once he saw me, sped off. The building was supposed to be vacant. I don't recognize the car or the subject.
Okay. Need to see your driver's license and registration, please.
Do you notice the subtle differences? In the second scenario, what the officer did was exactly what a security officer is supposed to do. He described in detail what happened. He described in detail what he saw. What he did was lay out for the police officer, probable cause. The police officer listening to this now is going to do what? Probably going to request that that trunk be opened. Probably going to want to search that vehicle. And by the way, that officer can search that vehicle based upon probable cause because motor vehicles are an exception to the Fourth Amendment requirement for a search warrant because of their mobility. What the security officer did was establish probable cause for the police officer. That's how it's supposed to be done. Nobody was called a thief. Nobody was accused of taking something they weren't supposed to have. A reasonable inquiry is now being made upon the articulation of a reasonable set of circumstances. That, folks, is all the difference in the world. Okay, what things are not seizures? Pretty clear indication of what things are. A lot of the things that we do in the course of our daily work as a security officer aren't seizures at all. Such things as asking questions.
Sure. Les, let me get you to take a picture of this right here. And ma'am, what's your name?
My name is Susan.
Susan? Okay. Okay, ma'am, the ambulance is on the way, but I have to ask you a couple questions, okay? Okay, what happened? Exactly.
Well, I came around the corner. I was leaving. I had been shopping here this afternoon. As I came across here, I evidently tripped over this mat that's curled up, and I fell and I hurt my ankle.
Okay.
Swelling.
Okay, you told me your name was Susan, right? Mm-hmm. Can you last name?
Susan Smith.
Okay. Social Security number if you want to give it.
We can conduct an inquiry into what's going on in a particular location. What happened here? How did this happen? How did this person get hurt? How did so-and-so fall down the steps? What happened to this? The asking of questions and conducting that kind of an inquiry is not a search. We can just ask questions. We're in the question and asking business. Another thing that is not searching or not seizing is the unintentional limiting of movement. As long as it's unintentional and not done in any way to restrict anybody's freedom, we don't have a problem with that. And then, of course, consensual encounters, where somebody has said, for example, as a condition of employment, they will allow their car to be searched before it's caught on the company property. They've given consent. They've at least implied consent. If you enter a military installation, there's a big sign there that says, vehicles entering this installation are subject to search. If you don't want them to search your vehicle, don't drive in there. If you drive in, you are giving consent for them to do that. That's a consensual encounter. And that's what we need to keep in mind here. Ultimately, when we seize a person, here's what the courts have held. And this is something the security officers need to be conscious of when we're talking about the ultimate kind of a seizure, an arrest. If the person being seized reasonably, there's the word again, believes that they were not free to go, they were arrested. That's what you need to keep in mind. The court does not consider an encounter between a security officer and a citizen a seizure unless some things have happened. First, there was a show of authority, either real or implied. There has to be that. A lot of folks don't know the difference between a security officer and a police officer. It's all a uniform to them and they don't care. Security officers know what their status is, and they have to make sure that they don't use somebody's implication or somebody's misapplication of the facts to think that they're a police officer. That's not allowed. That kind of trickery is not allowed in there. So that show of authority, either real or implied, and the person who was stopped must reasonably believe that they were not free to go. Now let's talk about that for a second. A situation where an elderly person was told by a security officer, and this is a situation that I recall reading and discussing and investigating with some other practitioners. An elderly lady on a riverboat was told by a security officer, wait here. She grew up in an era where if somebody in uniform told you to do something, an authority figure told you to do something, then that's what you did. So she stayed right there. The officer went off and in the conduct of the investigation forgot he told this lady to stay there. Went back a couple of hours later, she was still there. As far as she was concerned, because of her age, because of the way she was raised, and because of the conditions, she reasonably thought that she was arrested. On the other hand, a street-smart kid who knows a security officer is a private security officer, and the officer says, you wait here, and turns his back to go do something else, and the kid takes off like a rabbit, that kid was never arrested. He was never stopped. He didn't believe for a second that he was arrested. The person stopped has to reasonably believe that. Let me go back to another comparison for a minute that hopefully will stop and will help clear